Hello, my name is Chris Elnicki. I am the statewide senior education attorney for Team Child, and today I wanted to go over the topic of school discipline, specifically school discipline for children with disabilities who qualify either for a IEP through the IDEA or through a Section 504 plan via Section 504 of the Rehabilitation Act. A few things I wanted to talk about before we get started are some possible unique circumstances in the discipline process. We will have discipline differences among different school districts. We'll have discipline differences from school to school. Remember, discipline can mean anything from reprimand in the classroom to exclusion from school to expulsion from school. So everyone does it a little bit differently, and it's a good idea to keep that in mind and reference school handbooks and how certain school administrators do that per setting. It's important to remain flexible in your approach, how you address school discipline issues with children with disabilities. You may have to change your approach, you may have to change your strategy, you may have to change your thinking a little bit to adapt to how things are going. And you may have to educate people about the law. I understand that you're probably not an attorney, but sometimes you with a little bit of internet research and a little bit of help from others, you may know the law better than the school does, so you may have to tell them, and that's okay. So keep all those things in mind, and it's always okay to reach out for help from nonprofits and from school lawyers in your area as well. I wanted to provide a roadmap of what we're going to talk about and how discipline works. I want to speak about the basics of school discipline, how you can investigate, strategize, and prepare for discipline hearings and appeals, how you can tackle appeals, how you can talk about readmission and reengagement in school, and the school enrollment in general. And kind of all of these things will touch upon school discipline, but also school discipline specifically with disabled children and children identified under the statutes I mentioned previously. So the basics of school discipline are rather unique. There are different types of school discipline. We're going to talk about that in this presentation. Everything ranging from reprimand by teachers to exclusion from school and the relevant special education implications. The limits to school discipline, what schools are allowed to do and what they're not allowed to do, the rights that students have when they're being disciplined, and the manifestation hearing process for youth with special education identification and 504 plans. These are all work together, and each one of these items kind of should be addressed every time a student receives discipline. We also have different legal authorities that are relevant in every discipline proceeding. We have the Washington regulations, statutes. What's very unique is number 3. For due process and for special education issues, we have due process decisions in the common law. And what that means is sometimes you may have to reference cases that have happened before. So a great idea is when you're having complex discipline issues that may have been involved in due process hearings before, you can look up on OSPI's website and you can see old due process hearings that involve discipline and see if they have issues in common with you. OSPI also offers district policies and guidance. This is great because they can often be relatively neutral, kind of rules for how discipline is supposed to happen and how the state has told its school districts this is the way that it's supposed to be. Also, the Washington constitutional right to an education is very powerful, and it's a paramount right in the state of Washington. So it's sometimes if we're dealing with issues of exclusion or more significant deprivations of education, you can refer to the Washington State Constitution as well. We have the different types of discipline. We have classroom responses. Classroom responses are your typical day-to-day classroom interactions with teachers or paraeducators and students, and that can be some sort of verbal reprimand, a written reprimand, a call home, those types of things. It's careful not to include children being sent home for the day. While that may sometimes be framed to parents as a classroom response, that's really more of a more serious type of discipline. School-based responses to the right are more of restorative justice, essays, after-school detentions, something that would require a principal to kind of dole out some sort of disciplinary plan. In-school suspensions are suspensions where the student still goes to school, but they're often segregated from their peers or located in a single area as a punishment for a disciplinary event. Short-term suspensions are suspensions of 10 days or less, and those are where a student is required to spend that time outside of the school building. Long-term suspensions are more than 10 days, but they cannot last for more than an academic year. It is one of the more serious types of school exclusions, and those are different from emergency expulsions. Emergency expulsions only occur up to 10 days. Expulsions that occur for not more than an academic term are functionally equivalent to long-term suspensions. They're called expulsions, but again, they cannot last more than an academic term. And the exception to that are when there's firearms on school grounds. A student can be suspended or expelled for up to a year when that's the case, instead of beyond an academic term, but that is still limited to a year removal from school. There are limitations on suspensions and expulsions. For example, schools must involve parents early in efforts to support the student in meeting behavioral expectations. And we see this in cases where students kind of out of nowhere receive more significant suspensions or expulsions. We really should be asking ourselves, has this happened in the past, and what is the school district doing to help a student in these areas? The district also has to consider the student's individual circumstances and the nature of the circumstances of the behavior violation to determine whether a particular length of exclusion is warranted. A good example of this is when we have truancy issues, right? A truancy issue isn't usually addressed through a suspension. We have to look at what's going on, and then how do we deal with that particular violation of student conduct, and is removal from school appropriate, and then how long of a removal is appropriate. Any child who's excluded from school has to be given the opportunity to receive educational services, and for special education students, that includes your related services. It also includes specially designed instruction and special education. So if your child is supposed to receive occupational therapy, speech-language therapy, if they're supposed to receive vision therapy and services for blind students or deaf students, all that needs to be provided, but that will most likely be provided at home or in the community. So keep that in mind. Finally, another limitation on suspension and expulsions is districts have to plan for reentry. They're not permitted just to exclude a student and then not plan for them to re-enter. Students must have a meeting and then plan for the re-entry of that student. Schools are required to attempt one or more other forms of discipline first. So for incidents where that may be recurring, it should be rare for schools to go straight towards short-term suspensions and in-school suspensions. Before the principal of a school can come up with a plan for short-term suspension and in-school suspensions, they must have an informal hearing with the student. They must discuss the notice of the violation, explain the evidence against the student. They must explain the discipline and give the opportunity to share their perspective. School districts must also offer support to keep the student current with assignments and coursework for all of their classes. And keep in mind, this is specific towards short-term suspensions and in-school suspensions. Despite the fact that schools must offer support to keep the students current with their assignments, they must also have the right to appeal orally in writing, and the superintendent or designee must provide a decision within 2 days of the appeal. So these are unique to these situations. Just because a student is being disciplined in school, or it is a short-term suspension, doesn't make it less serious. We do know that these types of suspensions can be very disruptive to students, and if a student receives these type of discipline, they should be aware of their rights and the limits to those. For long-term suspension and expulsions, there are also limits. Before a school can administer, they have to consider one or more forms of other discipline, and they have to seriously consider those forms. They cannot use long-term suspensions for discretionary discipline, and the exception to that are certain crimes and violations of statutes located in the RCW. They cannot exceed a length of an academic term, And you cannot impose long-term suspensions for students who are in kindergarten for 4th grade. And for children of those ages, those exclusions are particularly disruptive. They're not particularly effective for causing changes in behavior. There are limits for long-term suspensions and expulsions, and there are exceptions. Remember, for firearms specifically, these types of discipline can occur for longer than one academic term. They can last for up to a year. These types of discipline are also particularly often used for violent offenses, sex offenses, and other serious violations of the RCW they're applicable to. They're also used in situations where behavior can adversely affect the impact of safety of other students. Other types of discipline can be turned into long-term suspensions or expulsions if the school district has determined that a student returning to school would pose a imminent danger to other students or school personnel. This is frequently used and sometimes overused. So think to yourself when this is something you hear. Is this a legitimate threat to students or personnel? Oftentimes, the student will not be a threat, but the school district will say this anyway. And it's important to keep that fresh in your mind as to whether or not this type of expulsion or long-term suspension is legitimate. These types of suspensions and expulsions are often used if a student would pose an imminent threat of material and substantial disruption to the educational process. Also, this is frequently used and misused by school districts. It's important to weigh the evidence fairly as to whether or not this is a real threat. Often, especially for children with disabilities who have IEPs, these types of threats of disruptions are overstated or misstated. And, if these types of disruptions are associated with behaviors that have a relationship to the student's disability, these types of expulsions and suspensions for these reasons are not appropriate. Emergency expulsions are appropriate or are able to be used by school districts if one, sufficient cause is found where a student could pose an immediate or continuing danger to other students or school personnel, or they are an immediate and continuing threat of material and substantial disruption to the educational process. We've seen this language before, and even despite whether or not these factors are true, emergency expulsions cannot exceed 10 consecutive days. And this is really important to keep in mind because we see this abused by school districts quite frequently. We see school districts saying, well, this particular student is a danger or has the behavior that they exhibit has the possibility to disrupt the educational setting. And what the law clearly says is, regardless of whether or not those are true, these emergency expulsions cannot exceed 10 days, and they must be converted to a different form of discipline. And just like other forms of expulsions or exclusions, families have the ability to appeal these types of decisions of school districts. Students have rights, and it's important to know those rights. And they have rights in order to keep them safe, but also to optimize their ability to learn in the educational environment. Student rights for long-term suspensions and expulsions are pretty straightforward. They have a right to notice in writing of the opportunity for a hearing, and that should be delivered by certified mail to the student and their parents or guardian. And this is really important because notice allows families and students to know what they did wrong or what the school thinks they did wrong. It allows them to know why they're being disciplined and how to appeal. And those are really important notices. And if you get a call from a school district saying, hey, we're long-term suspending or expelling your student, it's good to know why. And keep in mind you're entitled to a written notice. So, don't be satisfied with a verbal notice. You should request a written notice. These notices should be in the predominant language of the student or parent and guardian. They should specify the alleged misconduct and school rules. They should set forth the corrective action proposed and what the school district plans on doing. They should let you know you have a right to a hearing. And they should let you know the procedures to request a hearing and how you should appeal. Now, this is really important. If the school district doesn't hear from you in response to their letter, they will assume that you've waived your right to an appeal. So it's always good to request a hearing in writing, so you're able to show, hey, I did this thing that you told me I had the ability to do, and you can't say that I sat on my rights. As long as you request a hearing, you should have a hearing, and you should have an appeal. And to do that and to make sure that there's a record of doing so, you should always do so in writing. Students should be aware that they, in the face of disciplinary action, have the right to an informal conference, an optional conference. They always have the right to appeal when they're being disciplined. They have a right to hearing in front of a hearing officer. What this means is the school district should have a impartial party hear the appeal of the hearing and the hearing itself. Often in school districts, the initial appeal for discipline is heard by a superintendent or by a hearing officer who is paid for by the school district to do the hearing. Students should have the right to examine school evidence and a witness list before a disciplinary hearing happens. You should request the evidence the school district has against you and who they plan to call as a witness. You should have the ability to challenge school evidence, and you should have the ability to present your own evidence. Students with IEPs and Section 504 plans have additional rights in the face of school discipline. It's important to know that the IDEA and Section 504 of the Rehabilitation Act allow you to have additional rights to a manifestation determination or manifestation hearing. What that means is within 10 business days of the disciplinary event that results in a change of placement, and I'll go over what that means later, school districts must have a hearing to determine if the conduct in question was caused by or had a direct and substantial relationship to the child's disability, or 2, if the conduct in question was the direct result of the local education agency's failure to implement the IEP. And what this means is, number 1, we're asking, is the event that happened and the behavior that happened caused or related to my child's disability? And 2, is what happened at the school because of the district's inability to follow through with the IEP? And that could be the behavior plan, or that could be other accommodations and specially designed instruction in the IEP. Keep these questions in mind during the manifestation determinations, because oftentimes the school district will have most of its conversation around one, or sometimes even none of these specific questions. This is a group decision, often with the entire IEP team present, but also with a 504 team as well. If a child is not identified under the IDEA but is disabled. If a particular action or behavior is found to be a manifestation and the team who's conducting the manifestation determination hearing decides that, then their next steps should include a functional behavioral assessment of the student, which is often referred to as an FBA, and a behavior intervention plan. Normally this results in a child returning to their placement where they were before the disciplinary event, but sometimes there can be complications. That being said, immediate return to the regular education placement is the right of the student. These are kind of complicated terms. A functional behavioral assessment is a diagnostic tool to determine what's causing a child's behavior and the source and reason why that behavior is occurring. It allows school teams to find target behaviors and then identify behaviors that they would like to replace those target behaviors. And then often they include different reinforcement systems, positive and negative, to help achieve that replacement behavior. Behavior intervention plans are plans that are used to implement that information that they gathered from the functional behavioral assessment. Functional behavior assessments are diagnostic tools that often rely on both observations of students, but also historical data located in the IEP data itself, the progress data, as well as anecdotal observations by teachers and faculty. The information gathered from a manifestation determination, often with the data from the FBA and the information discussed during the behavior intervention plan, is a useful tool for the team in determining if any changes need to be made to the IEP or the 504 plan. There's a lot to think about in these particular types of cases, and discipline of a student who receives services through an IEP or a Section 504 plan could cause what's called a change in placement. And really what that means is a substantial change in the amount of service hours they receive, the physical place in which they're educated, the method in which they're educated, or a combination of all those things. Manifestation determinations may be the most important meeting in a disabled student's school career. And the reason I say that is because it could mean the difference between a student immediately returning to school and being expelled for an academic term. There's a lot to be won and a lot to be lost in the manifestation determination. If a particular behavior is seen to be a manifestation of a disability, like I said, a student should then return immediately back to school. But if it's not, and it's found not to be a manifestation, generally the student can be disciplined as a regular education student. And what that means is, for those serious behavioral infractions of, expulsion up to an academic term, that's what you're looking for. I mean, that could be what you're looking at as a student with a disability. And those could be really disruptive, especially for students with specific learning disabilities and who qualify under other identification categories. It's important to know as a team, what the roots of behaviors are and why behaviors are occurring. When we talk about really successful IEPs and 504 plans, and how they interact with behavior intervention plans and what makes them successful, really we're aligning several different things. We're figuring out through the functional behavioral assessment why a student's doing a certain thing, or a hypothesis on why we think that's happening. We're then identifying things that are occurring in the environment that both contribute and occur at the same time as those behaviors. We're identifying things that we can do preemptively to help minimize those behaviors, and those can be therapeutic supports, those can be environmental things like having dim lights or making sure the student's comfortable. And then we're also identifying replacement behaviors, and to do that we often consider teaching strategies. And what that means is, what you really should be seeing in your IEPs with students with behavioral needs in their IEPs is there should be specially designed instruction, and what that means is individualized instruction in the areas of social, emotional, behavioral functioning. And what that could look like is different for every type, every different school and every different type of IEP, but it often relates to discrete skills that can be taught to a student. So it's good to ask, what discrete skills that include things like coping mechanisms and de-escalation strategies are being taught to my student so that they're able to make progress and use those replacement behaviors. So keep that in mind. Really everything from the goals to the teaching strategies to the SDI to the progress reports should all be in line and really identify these issues. We should also ask ourselves, what about kind of more complex disabilities like intellectual disabilities and autism? For these types of disabilities, really a vast amount of behavior is substantially related to the student's disability. And in a lot of ways, these arguments are easier than saying that, for instance, that a behavior is somehow substantially related to a academic-based specific learning disability. For instance, it's easier to say, this may have happened because of my child's autism diagnosis than it is to say, this happened because my child has significant difficulty reading, which is still possible. But for these more complex disabilities, it's important for the school district team to know, how your child expresses these disabilities and what their behavior is in the home, what their behavior is like in the community, and if there's any specific triggers. The very common saying in special education, especially for children with autism, is when you met a child with autism, you've met one child with autism. And what that means is one child's autism may not look like another child's autism. So it's important to encourage school districts to stay away from generalities and what may be the popular understanding of what an autism diagnosis means, or a Down syndrome diagnosis means, or an intellectual disability diagnosis means, and really help them understand of how that reflects with your particular child and how your child expresses that. And it's a great idea to bring in particular service providers like physicians, psychiatrists, and mental health professionals to help, with appropriate permissions, of course, help explain some of those, individual specific things to the school district. We mentioned before that manifestations occur when there's a change of placement or a threatened change of placement for a particular behavioral incident. So the federal regulations define a change of placement as the following, and this is what triggers a manifestation determination. 1, the removal is for more than 10 consecutive school days, or 2, the child has been subjected to a series of removals that constitute a pattern. And what constitutes a pattern could be several different things. It could be a pattern because the series of removals total more than 10 days in a school year, because the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in a series of removals. Or 3, because such additional factors as the length of each removal, the total amount of the time the child has been removed, and the proximity of the removals to one another. Now, it's very often that school districts will only keep fresh in their mind the number 1 rule, which is the removal for more than 10 consecutive school days. That is the most common reason for a manifestation determination. That's the one that you most see school districts get right in initiating. But keep in mind that you're entitled to these manifestation determinations if if the discipline is because of a series of removals that total more than 10 school days in a school year. So, if your child is constantly being suspended by the school district and it is now day 15 total, ask for that manifestation determination sooner rather than later to determine if it's substantially related to the disability. If we're seeing behavior that's the same, for example, like a student acting out if there's a loud noise like a fire alarm, that's a great time for subsection 2 here, because the student's child behavior substantially limited the child's behavior in previous incidents. You see this a lot with children with trauma. If there's a specific trigger that triggers that trauma, this is a great way to use that subsection and say, hey, every time my student sees this particular person, it causes them to panic and misbehave. That's a great time to use that subsection 2. And then also subsection 3 is kind of a catch-all. If you're starting to see similarities between removals, or if there's been particularly long removals or it's detrimental to the student, that's a great time to bring up subsection 3. Also, down here in section 1, if the public agency determines on a case-by-case basis whether the pattern of removals constitutes a change of placement, the district can also make that determination. What do we do if the district has determined that a particular behavior is a manifestation? Well, the student goes back to the educational placement. They go back to their regular education environment immediately. But also, the school district is required to create that functional behavioral assessment that we just discussed. And they should use both observational data that's happening now, currently, but they should also look back at historical behavioral data. And finally, they should create a functioning they should create a functioning behavioral intervention plan for that student. There are some special circumstances in which a particular behavior can lead to a 45-day placement or an interim alternative education setting. So even if a student is found to have engaged in a behavior that is a manifestation of their disability, they can still be excluded for up to 45 days in an alternative setting if the following occurs. They carry a weapon to or possess a weapon on school premises, or at a school function. A good caveat to this section is the types of weapons are specifically listed in federal statute, which is referred to in this statute. 2, they could knowingly possess or use illegal drugs or sell or solicit the sale of controlled substances on school property, on school premises, or at a school function. Or 3, they could inflict serious bodily injury upon another person while at school, on school premises or at a school function. And serious bodily injury is a serious injury. We're not talking about your basic school fist fight. We're talking about serious, painful, and long-lasting injuries to other people. What happens if a child is placed on a 45-day placement, or the behaviors are found to not be a manifestation? Well, regardless, school districts must provide educational services to the students, and they must provide the services outlined in their IEP. If it's not happening in a regular education setting, IEPs must be implemented with equivalent services. And there are requirements that students attend the LRE and are not segregated or still in effect. excluding children for no particular reason or excluding them in isolation is not appropriate. Section 504 protections are also still in place. What if a child has not been identified, but yourself or the team believes the child may have a disability related to a disciplinary incident? Well, an unidentified child may assert IDEA protections if the district had knowledge of the disability. Knowledge is considered to be awareness of a concern in writing, a request for an evaluation, or if an LEA has concerns regarding a specific pattern of behavior. These are for situations in which a student engages in particular behaviors and it becomes relatively apparent, through a parent asking for help in writing, or a school district saying, hey, we think these may be, autism-related behaviors or ADHD-related behaviors, things like that. And they've occurred, and the team is saying, hey, maybe these are really related to this disability. For, these types of protections, if it is found that the student is disabled, and the way this often happens is, if during a disciplinary proceeding, if a parent asks for the student to be evaluated during discipline, the evaluation will be expedited. And if that student is found to be eligible, they're then able to receive special education protections. Now, this is not applicable if a parent refuses the evaluation. So if you believe that your student may have a disability that is related to what is going on behaviorally, if we can make that connection between behaviors and disabilities, and we think that's possible, the family definitely should consider having that child evaluated so they can receive some of those protections. What information should we gather when we're dealing with a manifestation determination or with a special education hearing? Well, you should always work hard to gather as much documentation as possible. That could include the notice of discipline and email correspondence with schools. Those are very important. You can also ask for email correspondence from the school that they had with each other. It's often very helpful to ask for special education related emails that specifically mention your child. Ask yourself what evidence exists for this particular disciplinary infraction. Is there camera footage? Do you have any forensic information, whether that be digital, video, or audio? Are there any witness statements? Do you know of anyone who witnessed what happened, and if they'd be willing to speak to the board or to the disciplinary appeal hearing officer? Figure out the dates of when the school suspension began, and make sure that your timelines are correct. Make sure you don't lose out on your ability to appeal. Collect as much special education or 504 plan information that you can that could be relevant. Well, it's not specifically listed in the regulations or statute, boards and hearing officers often want to hear this information. Get as much background about the school circumstances as you can, and also, if you need to, fill out releases of information with school providers or other education providers or mental health providers as well. I've included on slide 23 some basic timelines for long-term suspensions and expulsions. I wanted to speak to you briefly about a particular warning as you're going into the realm of school discipline. Keep in mind and keep it at the front of your mind that the school district may have referred your student to law enforcement, and charges may have been filed against your child, or also those charges may be pending. And it's really important that if you're aware of any criminal charges, to speak with your defense attorney, whether that's a public defender or you have a private defense attorney. It's really important that your defense of school discipline does not contradict your criminal defense. And if your student is planning on testifying or speaking in their defense with the school district, it is essential that they consider their Fifth Amendment right not to incriminate themselves in their criminal proceeding. And if there is criminal charges, I highly suggest that students not participate in testimony in their disciplinary defense. What that means is you may be calling other witnesses to testify about what happened, but not necessarily the student. And keep in mind, you want to avoid statements occurring generally in the discipline hearing that you don't want to be repeated or used in the criminal case. There are often cases where there are issues in obtaining evidence in discipline hearings. There are a lot of different sources of evidence. Sometimes it can be difficult to obtain and organize. But keep in mind that the school level administration is in charge of discipline, and they often have information related to the disciplinary incident. So ask your school district, hey, I would really like to see the investigation or the investigatory materials used in this particular case. It's a great idea to call the district administrator who's handling the discipline as a witness, but also keep in mind that they could be a great source of evidence. And if you are aware that the district has an attorney, or you have an attorney, it's a great idea for you or your attorney to reach out to the district's counsel. Great witnesses for school district discipline appeals are school resource officers and vice principals. It's frequent that they are involved in the incident or were there and observed it. Teachers and students testifying against your client or in support of your client are great sources of information. Keep in mind that there is a disclosure requirement for evidence. And the administrative code requires, in advance of the hearing, that the school district provide you a list of the evidence they plan to use against the student and also a list of witnesses. So I always recommend that you provide your witnesses and information early to the school district and ask them to do the same. I've included a sample letter of how you may request information from an attorney or from a school administrator. District policies are often a great source of information and help. They can include helpful policies in your discovery and evidence. Oftentimes school districts get their own policies wrong, so you may be able to surprise them by knowing their policies better than they do. Make sure you try to gather the following: policies defining the infractions, district policies on hearing processes and rights, and the district's progressive discipline policy. Progressive discipline policies are policies that state that one type of severe discipline may not be appropriate if less severe forms haven't been tried yet. I've outlined the discipline hearing format of how it typically occurs, but this could be so different depending on the district and the administrators involved. But most frequently, what you can expect is both yourself and the school district providing an opening statement, the school district presenting their case against the student and the evidence they have in support of why the discipline occurred. Sometimes these are quite brief. You then hear the student's case of why the discipline or the resulting disciplinary exclusion is too harsh. And then finally, you hear the final arguments. Keep in mind for your opening statements, you should keep it short, explain why you're appealing, why the hearing officer should side with you, and keep in mind that you really clearly want to state to the hearing officer what you want them to do. When the school presents their case, make sure to take good notes and write down the points they make and how you can refute those points. Remember, you're allowed to ask those witnesses questions. You can ask questions of the school witnesses and ask them for the basis of their knowledge. You can also object to the basis of that information if you believe it unfair. For your student's case, make sure you know that you can produce testimony and documents. Do you have mitigating evidence to show that the student may have already shown that they are sorry for what they've done and that they shouldn't be disciplined? Be careful of the student testifying. As we mentioned before, it may not be appropriate for them to testify. And this is where you want to make arguments and make your arguments known through testimony. For final arguments, it's always good to prepare an outline for your arguments before the hearing and then maybe adjust them based on what's been heard. But come prepared to give a final argument for why you think you are right. Make sure you respond to the school's arguments. It's always best to directly go and deal with the issues that they've identified rather than maybe ignoring them or bringing up additional information. At the end, make sure the hearing officer knows why they should side with you and what you want them to do. Students have rights regarding evidence. They have the right to review evidence before the hearing, and that includes witness lists. And you have the right to object if the district tries to get something into evidence without disclosing it to you before the hearing. An interesting caveat is the district may try to excuse witnesses who have given statements on the particular behavioral incident that has occurred. It's important that you object to districts using those written statements without corroborating them with that person's testimony unless they've done the following. School districts are only allowed to use those statements rather than producing the witness if the district made a reasonable effort to produce any witness and was unable to do so, or it's not advisable for a student witness to appear due to an expectation and fear on the part of the responsible district official that the student that the student is going to be retaliated against, or if the student appears as a witness. So what that means is you're only able to forego producing the student witness and use their written statement if there is a real threat of retaliation, if that student appears as a witness and the student has expressed that, or the district has made a reasonable effort to produce any witness and is unable to do so. Some practical tips for engaging in disciplinary appeals is the preponderance of the evidence standard is low. Preponderance of the evidence is described and defined as something being more likely to have happened than not. So have a story for your case so you can explain to the hearing officer that what is said to have happened most likely did not happen. It's good to emotionally win over your finder of fact, and who the finder of fact is in most cases the hearing officer or the board. Use law and facts to back this up. Really allow everyone in the room to understand emotionally where you're coming from and why the discipline is not appropriate. It's great to bring a support team. Having as many people as possible in the room with you can help you prepare and help let people know that your student has a great support system and may not be deserving of the discipline. I've brought WISE teams, I've brought mental health teams, I've brought community support teams with my students. Think about props. If it's beneficial to help explain your case through a poster, a PowerPoint, or other helpful tools, do it. Most likely that type of evidence is appropriate. But if you're not a lawyer, try to stay away from lawyer language. Don't try to sound more fancy than you need to. Just because you're in a legal proceeding, it doesn't mean that will help. Your hearing officer is also most likely not an attorney, so try to use as plain and straightforward language as you can. If you have objections to evidence, try to prepare those ahead of time and anticipate any reasons why you may object to evidence in the hearing. Finally, I just want to reiterate that if your student is removed, it is kind of outlined here that districts must provide educational services to suspended and expelled students. That includes special ed services, and that includes related services as well. The district must provide written notice of services to that student and family as soon as possible after their removal. Students must be able to continue to participate in the gen ed curriculum, meet standards within the district, and complete subject and grade level and graduation requirements as well. Districts must consult with the student, parents, and teachers. Districts should consider students' access to technology, transportation, and other resources. So keep in mind, if your student doesn't have access to the internet, the internet curriculum may not be appropriate while they're being excluded. Most certainly not. The district can provide services in an alternative setting, but those should be comparable, equitable, and appropriate. During the disciplinary process, school districts should have readmission on their mind. The goal for when students are disciplined and excluded for school, the ultimate goal should be, how can we bring those students back? Readmission hearings are basically applications to return to school, and the focus shouldn't be on what happened, but they should be on, is the youth ready to return? Families can make requests for readmission at any time after a student has been excluded. Each school district has a different readmission procedure, so it's important to consult student handbooks and district administrators to figure out how that occurs in your school district. One does a petition for readmission. It's always good to propose a plan to the district and explain why you're looking for readmission. It's good to involve the student in that plan so everyone's on the same page. The family, the school, and the student should all be working together. The district should be holding re-engagement meetings to plan for the opportunity of the student to return to school. These have to be held within 20 days of the imposition of a long-term suspension or an expulsion, and they should focus on how the student should re-enter the school district. During the re-engagement meeting, the student the family and the school should discuss a plan to re-engage the student in programs. And these don't take the place of readmission petitions. Re-engagement meetings are a completely different type of meeting, and they have to happen regardless of whether or not the family petitions for readmission. I hope that this slideshow and these points have helped, and they provide a good guidepost for how to engage in the disciplinary process, especially for those who have students who are identified as disabled under the IDEA or Section 504 of the Rehabilitation Act. These are often really confusing processes, and with these tools, hopefully the procedures and the policies become more accessible to you.